So good morning to all of you. Today we are going to discuss a case relating to anticipatory bail at the time of after filing charge sheet. So the point is, can anticipatory bail be granted even after filing of the charge sheet, or whether they have to surrender the court and get regular bail? This is the problem. Now Supreme Court has given a clarification for this also. In 2003, so old cases, since some of our friends has got doubts, since they asked, and for the benefit of all others, I am discussing these cases, right? So please remember, Supreme Court held that anticipatory bail can be granted even after filing of the charge sheet in hereafter in appropriate cases. So you can read this case as Bharat Chaudhary versus State of Bihar, 2003. All India Reporter, Sec.438 you can refer to that page, right? Here is also another case of 498A. So the appellant, Mr. Bharat Chaudhary, and his wife, both of them were accused by their daughter-in-law that they harassed her, and a case in under sections 504 intimidation, 498A and 406 IPC, that is they have taken away our gold jewels, allegation might be like that, and section 3 and 4 of the Dowry Prohibition Act, right? So the case was registered against them. Therefore, they filed a petition under section 438 Crpc anticipating their arrest, right? And it was rejected by the High Court at Patna, right? So, basing on the agreed by the order of rejection, now they have approached the Honorable Supreme Court of India by filing SLP. Right now, as usual, Supreme Court of India has sent notices to all the parties, that is even the High Court also. Now, and at the same time, the Supreme Court gave an interim order not to arrest the accused in the meanwhile. Right now, the advocate on behalf of the state of Bihar, that is Patna, he raised a typical legal point, or you can say he has raised a legal objection, stating that section 438 would not apply because the charge sheet has been filed. When once the charge sheet is filed, so no question of anticipatory bail, only regular bail, that is under section 439 CRPC. The only course left to them is let them go to the magistrate or to the police, surrender, then apply for bail. So that is the objection he has raised, and that is his contention, right? The only remedy is so and so. Now he has placed reliance. The state placed reliance on the case of Salahuddin Abdul Samad Sheikh. Salahuddin Abdul Samad Sheikh versus State of Maharashtra, 1996. But a perusal of section 438 CRPC, it clearly says that there is no restriction to exercise the power even the charge sheet is filed. Here it is only clearly stated that whenever any person is apprehending, that will be arrested, maybe falsely or whatever it is. So in order to avoid the same, he is requesting the court, he is coming to the court with folded hands, stating that in case of arrest, he has to be released on bail or not to arrest him. So that is the only request. It is not very specific that this application should be filed before filing of the charge sheet. Section 438 says, where any person has reason to believe that he may be arrested on accusation of having committed a cognizable offense or a non-bailable offense, to be precise, he may apply to the High Court or the Court of Sessions for a direction under this section that in case of arrest, he shall be released on bail. That's all. There is no specific thing. And you may be knowing the provisions also. So the court will take consideration into, number one, gravity or nature of the offense or accusation. Then antecedents of the applicant, whether he is the so-called, whether he has committed the offense freely, whether he is a danger to the society, whether he has previously undergone any imprisonment of conviction in respect of any cognizable offense, then the possibility of his escaping from justice, and whether the allegation has been made with the intention of injuring him or causing him, so all these things causing harm to him. All these things they will take as consideration, and they will grant the bail or they may not grant the bail. This is the purely personal discretion of the judge. But here the point is, when the charge sheet is filed, can't he approach the court for 438? 100% he can do it, no problem. So this is what is clearly told by the Supreme Court. Normally, even I was also under the wrong impression that once the charge sheet is filed, you cannot go for anticipatory bail, you can go for only regular bail. But now it is clear, very good judgment. Please read it and enrich your legal knowledge. Thank you very much.